Good morning, my name is Jane Lee from PSY305 Group 1, and our group will be presenting our topic titled Technology as a Threat to Privacy. The objective of our poster is to inform how the use of technology can be a threat to personal data privacy from different ethical perspectives, and learn about various data protection concepts. Now, I will move on to the concepts and definitions. We would like to introduce a few terms related to our topic. The first term is data privacy. Skinner, Hahn, and Chang defined data privacy as the protection of an entity's personal data that is being collected, shared, and stored. The next term is personal data, where according to the Personal Data Protection Act, personal data refers to data which the information is related directly or indirectly to a data subject who is identifiable from the information. Some examples of personal data include name, address, phone number, email address, banking details, and photos. Then, another term is sensitive data, which refers to any personal data consisting of information as to the physical or mental health condition of a data subject, his political opinions, his religious beliefs, or other beliefs of a similar nature. Next, we discuss key parties involved in using data. The first one is data subject. This refers to an individual who is the subject of the personal data. Another key party is the data user, defined as a person who either alone or jointly processes any personal data or has control over or authorizes the processing of any personal data. Some examples of a data user include Maybank, DG, and Malaysian Airlines. Lastly, data processor is described as any person other than an employee of the data user who processes the personal data solely on behalf of the data user and does not process the personal data for any of his own purposes. Examples of data processors include third parties, vendors, and dealers. That's all from me.
My name is Matthew Wong, and I'll be presenting the current issue towards technology and data privacy. First, let's understand the various field personal data are obtained and used. Companies such as bank, business, healthcare, e-hailing, like Grab and Foodpanda, all stores users' data, and in general, users' data is shared with third party without us being aware of it, as we mostly believe that our data is protected by the law. Hence, many countries have established legislation to secure individuals' data privacy. Nevertheless, according to Malaysia Kini, Malaysia is ranked as the 5th worst performer of privacy among other 47 countries like India or China. Moving on to the next section, PDPA stands for Personal Data Protection Act 2010, whereby this act aims to regulate user data in commercial transactions in Malaysia. PDPA is enforced on 15 November 2013 in Malaysia. As stipulated under the PDPA, users need to be protected to prevent any form of abuse against the storage or processing of personal data of individuals, whether it may be in electronic devices or manual filing system. However, the PDPA does not apply to several situations. For example, the federal state government, personal, family, and household affairs, and any data that's processed outside of Malaysia and non-commercial transactions such as social media and credit reporting agency. So that will be all for me.
All right, so it's really apparent that Malaysia needs to adopt additional laws to increase the safety of personal data privacy. And in the process, some principles have to be adhered to. My name is Brian Tay, and I will be discussing some of the principles of data protection from the European Union's General Data Protection Act to better understand the data protection done by other countries. So we first decided to highlight the principle of lawfulness, fairness, and transparency, which basically ensures that in a clear, plain, and accurate manner, organizations need to explain to the users where, what, and how their data is being collected and used. Then, there's the principle of purpose limitation, which looks at how organizations need to stick to the previously agreed boundaries of where and how their data is being used. So if a shopping app says like they only need my location for delivery optimization, I wouldn't expect them to share my address out to other companies without my permission, especially when that wasn't what I originally agreed on. And finally, in the principle of integrity and confidentiality, which basically means that organizations need to ensure that the safety and security of our data and privacy are protected. And they can do this through technological and, if needed, physical measures. And it goes without saying that they shouldn't be sharing or selling our information out to any other third parties without our consent. So therefore, just as how psychologists utilize the APA codes for their conduct, Malaysians should also form some principle of data protection for collection when coming up with legislation. So we can do so by referring to the GDPR on how we can go about it. That'll be all from me.
Hi, my name is Wei Jun. I'm going to discuss a few individual rights from the UK GDPR relating to data protection. First and foremost, individuals have the right to be informed when their personal data is collected and how it is used. Individuals should also be provided with information that covers the purposes of using their data, how long the data will be kept, and who the data will be shared with. In short, these are called privacy information. For instance, the GDPR states that if personal data is obtained from another source, the individual must be informed of their privacy information, that is, the usage, retention period, and so on as mentioned earlier. In addition, the information provided must be in plain and concise language so that the normal population can understand clearly. It is important for individuals to practice this right as it protects them from any sorts of disadvantage such as reputational and monetary damages. Secondly, having the right to restrict processing means that an individual can request for their data to not be processed by organizations. However, companies can still store their personal data, just that they are not allowed to process it under the request. Despite requesting to restrict the process of data, individuals should still understand that their request can be ignored or lifted after a certain period of time and can be refused under other specific rules and conditions. For example, if the personal data is used for legitimate purposes such as scientific research for the public interest, the right cannot apply. Finally, the right to erasure, like the name, gives an individual the right to have their data erased from a database. However, like the right to restrict processing, it is not absolute and can only apply to certain conditions. One obvious condition that a person can request to have their data erased is when their data is no longer needed for the initial purpose. Like the aforementioned right, this right also does not apply if the data is used for a good cause. In short, while individuals have the right to have their personal data erased or restricted from being processed, it is not a definite answer to privacy issues as it is only temporary and can be refuted legitimately.
Moving on to our ethical discussion, I'm Macy and I will be presenting the first issue on how technology can threaten our privacy in terms of apps and their services. When using mobile apps or online service, it is common to sign up an account, which leads to the collection of personal data. The reason for companies wanting us to create an account is to obtain our data to increase user personalization. The data can also be used for marketing purposes such as sending newsletters or referrals to invite others to use the app or service. Now, the ethical concern here is the registration via third-party accounts such as Facebook, Google, or Microsoft may share some information with the app or service company. As an internet user, we tend to overlook this due to its convenience. It then raises the questions of who can access our data and the possibility of the data being used for other purpose than specifically gathered. Not to mention, having multiple accounts with the same login data makes cybercrime easy to take place. However, there is an exceptional scenario. Malaysia's My Sejahtera app collects personal data for the purpose of public health concerns. To elaborate, the app obtains personal information like name and identification number, and sensitive information, specifically location and one's health condition. With PDPA not applicable to the government as mentioned earlier, there is no laws in Malaysia to regulate this case. It should cast a doubt on how the government keeps our data safe and how often old data, such as location history, is raised.
My name is Eugene, and I'll be presenting the second ethical issue on audio recording and image screenshots, which can lead to misuse and how it could also violate another's privacy. To add on to that, recording a third party has no legal validity. It is important to highlight the benefits of having such features in a smartphone. Essentially, smartphone manufacturers included these features with hopes of providing their consumers the efficiency and convenience to record or save any information or memories they find useful online. However, there are some ethical concerns to how these features are being used for the wrong purpose. For instance, being able to save others' online photos, videos, or to secretly record people in public not only violates one's rights to privacy, it could also lead to unwanted crimes such as the circulation of unconsented sexual contents, blackmailing, pornography, or defamation. In Malaysia, there are few cases that highlights this particular issue. For example, last year, 4 women had lodged police reports after their photos and videos from Instagram were circulated without their consent on Telegram. Besides that, there are also cases of blackmailing where perpetrators threaten to leak the victim's private information online. Thankfully, there's a law in Malaysia, namely Section 509 of the Penal Code, which can be used to sue the perpetrators. Although the issues presented earlier are unethical, there is an exceptional scenario, particularly in the context of employer-employee disputes. In the Malaysian industrial courts, covert recordings can be used as evidence without the consent of defendants, as there are no statutory prohibition, and that parties must also follow strict procedures with proper documentations when presenting their evidence to the court.
My name is Chi Hui. The significance of our topic is to understand how privacy issues are often overlooked and how technology poses a threat in violating users' rights to privacy. The second implication is to allow Malaysians who may not be fully aware of the functions and limitations of Malaysia's legislations on personal data privacy to have a better understanding of their legal rights. Therefore, the implication for technology users is that they should be vigilant when sharing information online, be it in transactions, services, or social media. Moving on to future recommendations, we suggest that individuals be mindful and should always read up the privacy policies before consenting to a party's use of their personal data. For societies, companies that provide services should practice transparency in terms of managing users' data and provide their users the options to manage their personal data manually. As such, users can check their app allowed settings and uncheck any data they wish not to disclose. Lastly, it is hoped that the government will review PDPA and introduce new regulations pertaining to the personal data protection. Well, this brings to the end of our presentation. Thank you for your time and attention. We wish you a good day.